Well, if it appears that the constitutional rights of these citizens are being affected, that is the three accused, because this prosecutor, pursuant to constitutional law and more importantly constitutional cases, has held back evidence that was clearly indicative of exculpatory material, that is, evidence proving that they're not guilty, and he knowingly held that back from the defense team, then this is the type of case that may call for intervention from a neutral and detached party to see whether or not this case is viable at all. And I think it's probably a good strategy at this point to get a neutral and detached party in.
And for those who haven't followed every last detail, we know about him sitting on this evidence because of testimony of a DNA company.
Well, we knew through the state crime laboratory that there was evidence that indicated that none of the DNA material found in the alleged victim was from not only the three accused, but the other 45 members of the lacrosse team. Well, we now found out that a private company did a more specific DNA and more reliable DNA test that again showed that it was not DNA present from any of the three accused, the other 45 members of the team, or the alleged victim's boyfriend, which is completely different than what she said, because she said she didn't have any sexual activity for 1 week. We now know that she lied. We now know there's exculpatory evidence, and we now know that Mr. Nifong withheld this evidence from the defense.
Absolutely. And clearly this case seems to have just crumbled into nothing.
This case has not only fallen to nothing, but this case is an affront to the true rape victims in this country. And Mr. Nifong's self-absorbed, self-motivated desire to get himself elected and cling on to this dead case is set back the plight of rape victims probably 20 years.
Wendy, I hear you champing at the bit. Please, I think that you may be the last person who actually gives Mike Nifong any more credibility here. What's your problem with this, with constitutional case against a Nifong?
Well, let me just say this. I'm not the last person. I may be the last person willing to take the heat, because the victim is certainly taking a beating, as is Mike Nifong, and it's really unconscionably unfair. And here's why. You want to talk about hiding evidence. The defense has been handed thousands and thousands of pages of material since the beginning, and it's very well known that they are not sharing all the truth with us.
Let's talk about this specific piece right here.
The defense is not, well, let me just make one point, because it matters to the fairness of the process. And if you're going to bring civil rights violations against a prosecutor, what you have to do first is give the public all the evidence. The defense has refused to turn over to the public over 1,000 pages of evidence, and I want to know, before I pass judgment on this case, what are they hiding? Do we have eyewitness testimony? 30-some-odd guys were there. There's a good chance a few of them actually saw what happened and may well be cooperating. Are there photographs? We know there were before photographs and after photographs. There's a chance there are during photographs. So before I say let's throw the book at Mike Nifong and call for him to step down in federal investigations, I want to see all the evidence. I'm not going to judge this case based on defense spin and lies by omission. That's all we've gotten for 9 months. And all of this stuff about the federal investigation is a bunch of nonsense. All it means is somebody with power made a phone call, and I want to know,
protecting the constitutional rights of the accused is not nonsense, Wendy.
There's no evidence that the rights of the accused
Hold on, let's get a response from Drew here.
Let's understand why there's a need for a federal investigation. It's really not what's happening now, Michelle. It's the fact that we protect and preserve the grand jury process. You know, historically, the grand jury process is to protect the accused from the monarchy in ancient England. And that's the way it's supposed to work here. The reason for a federal inquiry is to see whether Mr. Nifong withheld exculpatory information, that is, evidence that proved innocence, when he presented this case to the grand jury. He was supposed to have done that. Remember, it's a one-sided process, and the grand jury relied on him to give a neutral and detached presentation of evidence, and it's looking now that he deceived a grand jury, and that's a major no-no.
He did not do that. Look, let me respond to this DNA stuff, okay? We all found out last spring that none of the DNA matched any of the guys. That's the exculpatory evidence they got. As soon as anybody was entitled to it, they got it. There's no dispute about that. What they didn't get was affirmative evidence that she had apparently sexual contact with other men. That is constitutionally protected. Private information. You want to talk about civil rights? Every prosecutor in this country dealing with rape cases knows you don't turn that over to anyone until a judge has a hearing. And a judge did have a hearing. Last week, he decided it was okay okay for the defense to get that evidence so they could make the argument that her vaginal injuries may have been caused by the other sexual activity. Fine. That's not a constitutional violation. That's what we call due process. The judge agreed they could have that evidence, and guess what? The vaginal rape case is now gone. The other rape charge, and that's what they call it in North Carolina, by the way, sexual offense is in fact rape. Any other form of penetration is called sexual offense. That charge remains. The only thing that's gone is the vaginal rape case, and this could be good news for the prosecution because without the vaginal rape charge, we're not going to hear about the other sexual acts she engaged in, and that's good.
Is it due process for Mike Nifong to have sat on the court, stood on those courthouse steps, haranguing and telegraphing what he thought about this case, poisoning the grand jury's opinion before they had heard all of the evidence? Is that due process?
No, look I am absolutely willing to criticize any prosecutor who goes overboard, but let me suggest to you that the defense has more than made up for that. And if they really think their clients are not getting fair shake, why aren't they screaming for a trial tomorrow instead of getting their political friends involved? Scream for a trial and let the truth come out.
You want to talk about politicizing? Let me read from an editorial in the LA Times today. Calling for Nifong to drop these charges, the rest of the charges. What is clear is that Nifong, whose election campaign for a full term overlapped with the investigation, lost control of his tongue and participated in the transformation of this incident from a case to a cause, usually an ominous development for the administration of justice. Do you agree with that, Drew?
I absolutely agree with that. And let's go back to his quotes during the pre-grand jury process. He said that he was absolutely sure there was a rape and that these young men acted like hooligans that were going to need their daddies to get them expensive lawyers. And I ask you now, who's acting like the hooligan now? Who's the one that a witness got on the stand from a private DNA company? You know, Wendy says we knew they didn't have, the DNA wasn't there. But Nifong wanted it so badly, he went and got a more Y chromosome specific analysis done by a private company because he wanted it badly. And when that test came back negative, the witness testified last week from the private company. Mr. Nifong said to him, we're just going to keep this one between you and I. I ask you, who's acting like the hooligan now?
Wendy?
That's just not fair. Look, that's not fair. No one should call anyone a hooligan. But if you want to compare who's tossing out the most nasty barbs, the defense wins by a landslide. Every day it's another press conference of misinformation and partial information. Both of you will agree with me, at least admit this much, that if there is eyewitness testimony from the defendant's friends, if there are photographs, that is damning stuff. And the public, justice, is entitled to know whether that evidence exists before anyone calls for this case to be dismissed or Mr. Nifong to be punished.
Well, Wendy, I think you may be waiting a long time. It seems like that the credibility of both this witness and the prosecutor have been completely shredded by their own hands. And we thank you both for joining us, Wendy and Drew.
You're
Next.